Hello viewers, here we are with your much awaited program on TVASIA Telugu. Manato unnaru immigration specialist, founder of Reddy Neumann law firm, mana talk show expert and our very favorite Rahul Reddy garu. Hearty welcome Rahul garu.
Thanks for inviting Sita garu.
Thank you so much, Andy. So there is a lot of exciting news that we are hearing. Last September low, about 100,000 green cards allocated. Dantone 4 years, the backlog got cleared, and it's still moving forward. So this year, 135,000 are newly getting added to it. So what are we expecting out of it, Andy?
It's definitely good news for a lot of Indians. We are expecting a lot of the dates to be moving. Out of this 135,000 green cards, though, at least 100,000 green cards will be going to the Indian nationals. The reason is that there are no other people waiting in line. Even if they are, Indians are waiting, I wouldn't say way ahead. They've been waiting for a long period of time. They are way ahead in the line. So most of the allocations that will be done, the 135,000, will go to Indians. I would expect at least 100,000 on top of the 20,000 we normally get it, will go to Indian nationals. Coming to the point, where did I got this number of 135,000? This week, State Department had in their YouTube presentation, they have discussed about what they're going to do about the family immigration green cards that they did not use in the year of 2020, which starts on 2021, which starts on October 1st of 2020 to all the way to September of 2021. As we know that because of the pandemic, the consulates are not open. Most of the green cards that are allocated to the family immigration, the preference categories, will be allocated in the consulates. Since the consulate closed, the law clearly prescribes that those unused preference categories will have to be given to the employment-based green cards. So it's not that we are waiting for any new law that need to be passed in the Congress. It's not that the administration can do anything at this point of time. Either the previous administration, the Trump administration, didn't have any option but to give the 100,000, approximately 100,000 green cards to us. This administration also doesn't have any choice but to give the 135,000 green cards to the employment-based. Since the backlog is mostly Indians only, there are not many people that belong to our country. Out of the 130,000, at a minimum of 100,000 green cards will be given to the Indian nationals on top of the 20,000 that we normally get out of the 140,000. So this is very good news. We are expecting the priority dates to move forward.
That's
one thing I want to tell you, Sita garu, is that in the YouTube presentation of the State Department, what you said was that 100,000 was been allocated. Yes, 100,000 was been allocated, and we have seen them. The USCIS has allowed us to file the applications in September, October, to an extent in December also. So, Sita garu, even though we allowed to file, though, they haven't moved the dates that fast. But the State Department said that by the end of the year, which is September of 2021, they are expecting the priority dates to move to the same dates as the filing dates in October of 2020. So that means that the final action dates, at least according to their department, are expected to move until January 1st of 2015 for the EB3, and for EB2, May 1st of 2011. That is what we are expecting the dates to be moved. If you have already noticed that, the first preference category is current. It's been current. And the State Department said that it's going to be current all along.
That's nice. I think there is a small technical glitch, and
we're good. We're good.
Okay. Awesome.
Let's go ahead with the questions, Andy. If you with the Sita garu, let's go with the questions from the live telecast. Do people have it, or let's go with the YouTube questions we have?
Sure. We will onboard the first caller here, Andy. I see the first caller ending with 2839. And before we take the caller's question, let's have the first YouTube question here, Andy. There are quite interesting questions here that we are seeing on YouTube. So the first one is from H1 So what he's saying is my old I-140 from company A still valid for getting an H1B extension? What is the status of my old I-140 from company A when I get new I-140 from company B with what about my priority date? Is it still locked for 2013? Just a quick question. This is for the caller ending with 2839. We'll get back to your question, Andy. Please go on mute for a few minutes.
So his main question is that if company A has filed an I-140 and got the approval, now he's moving to company B.
Correct.
And he's porting the date to company B. Even if the company A withdraws the I-140 approval, he would be able to retain the 2013 priority date. He would be able to extend the H1B using that I-140 beyond 6 years. He would be able to get his spouse, spouse, H4EAD extension even if the I-140 is withdrawn. Now he asks a second question, that is that what if the second company, that is company B, after porting the date and withdraws the I-140 before the 180 days? That will have no impact on company A's I-140. If you have one I-140, that's been approved for more than 180 days, it's not been withdrawn before January 17th of 2017, that I-140 now belongs to you. It is tattooed to your face. So even if the subsequent I-140s were been withdrawn before 180 days, it will have zero impact on company A's I-140.
Okay, that's good news. So I hope you got your answer here. This is for the viewer only. So thanks, Rahul Garu. Let's take the caller's question. Caller ending with 2839. Please go ahead with your question, Andy. You're on mute. Please press *6 to unmute yourself.
Can you hear me?
Yes.
Yes.
Go ahead.
Yeah. Hello, Rahul and Sita Garu. Thanks a lot for helping the H1B community.
Sure.
I have two questions, sir. The first being
hopefully this community will decrease significantly starting from October 1st. Maybe you'll move to adjustment of status.
Fingers crossed.
We are hoping. Excuse me. We are hoping so, sir. Sir, my first question is I have approved priority date of EB2 2011 from Nebraska Service Center in the year 2011. I got it.
2011. Thank you. I need that month date. Okay.
Yeah, EB2 June 2011, and now we had downgraded it to EB3, and we had received, and the documents were sent to Texas Service Center, and we received all the receipts, AP, EAD, and I-145 as well as I-485 receipts on March the 4th from Nebraska Service Center. So my approved EB2 was Nebraska. My documents were, downgrade documents were sent to Texas, but I received all the notices from Nebraska Service Center, sir. Now my question is, will it be considered as the same service center, and am I eligible for premium processing? And I heard that if it is, mine was a new petition, sir, new I-140 petition.
Yours was a downgrade application, which is, when you say new, you mean to say downgrade application. You didn't file as an amendment. All the downgrades, most of the lawyers, they all did new application only. I'd be very surprised if any of the people have done it as an amendment. So everything is a new application. Now the question is that even if the Texas Service Center doesn't have your original labor certification, can you apply for the premium processing? Yes, you can. Are there
sir, one question. I got the receipts from Nebraska, sir. Even though I applied for Texas.
That's fine.
I got the receipts from Nebraska.
Irrespective of whether you get it from Texas or Nebraska, it doesn't matter. Apply the premium processing immediately. You have nothing to lose. There are some cases that are getting rejected if we are filing in Texas. But when we are refiling the application, they're accepting it, and we got a lot of approvals. Even though Nebraska Service Center approved the labor certification approvals, we got the premium processing approved in Texas though. So irrespective of, you should file for the premium processing.
Sir, is there any time constraint, sir? I received the receipts on March 4th. Should I wait for 30 days and then apply for premium processing, or can I do it right up?
No, you should have done on March 5th.
Okay, thanks a lot. I have a second question, sir. My H1B will expire on October 31st. So I will be applying for my H1B extension in the month of May, because my wife is on in premium processing. My wife is on H4EAD, so I'm thinking of having a 5 to 6 months buffer time, because it's taking a while for H4EAD.
For getting the H4EAD, yes.
Yeah. One question is, like, by any chance, if I get any biometric appointments for either H4EAD or I-485 process by October 31st, can that be used for the other one, sir?
It could be used, but it will depend on the officer of the H4 application if they will be able to use it. It could be used. The main question that you need to ask the question is, if you get the EAD approval, do you actually need, from the adjustment of status, do you need the H1, the H4 plus EAD?
Oh, okay. Yeah, got it, sir. Yeah.
I don't know. I don't know. I request all of you guys, if your I-140 is approved, and it's been more than 180 days that the I-485 has been pending, you need to educate yourself more thoroughly on, do you actually need to keep on extending the H1, keep on extending the H4, keep on extending the H4 EAD? Every time you go outside the country, you get the stamping. Every time your spouse goes outside the country, you get the stamping. All 5 of these things, do you need all these things? What is the purpose of maintaining all these 5? Is it only to make immigration lawyers rich? Or is it, are you achieving anything? You need to ask this question.
To be precise, sir, most of them say it's just a backup. If something goes wrong,
you need to understand, certain times the backup misfires. When your H1 extension gets denial, it may have a negative impact on your adjustment of status application. I'm not telling there is no plus points at all, but I believe that there are more minus points in maintaining the H1B. It's up to you guys. I mean, you may be there for a long period. Who knows? So personally, I don't like to make immigration lawyers rich. That's not my purpose of living. Yeah, I like to make myself rich. That's different. But when I'm a client, I don't like immigration lawyers to. I didn't want it to make my immigration lawyers rich. That was not my purpose. But anyway, it's up to you. If you want to make me rich, or people like me, that's fine. Why not? Next person, please.
Sir, I have a June 6th, 2011, sir, in EB2, in EB3 a downgrade. So what are the chances that I can get, my date will become
based on what the State Department said in their statement, you have a very high chance of getting everything current by September. Now that's what the State Department said. I'm just mirroring what they said. I'm not making any statement. Let's go to the next caller.
There won't be any need for me to apply again for in EB2, sir.
Thank you, sir.
Hopefully so.
Thank you.
Hopefully so.
Thanks a lot, Rahul Garu. Thanks a lot, Sita Garu.
Sure.
Thank you so much. Just a very small request to the viewers, Andy. We have a lot of callers waiting. Let's be a little cognizant about the time and to speed up everyone's questions here. And thank you so much. Let's on with the next caller. It is 2345. Rahul Garu, let's take the YouTube question in the meantime, Andy. The viewer's question is, I and my kid received I-485 receipts, but my spouse application was returned back, saying the principal application was rejected, and then saying the page was missing, which isn't. What would you suggest?
Well, principal's application was not rejected because your application is accepted.
Mm-hmm.
So definitely that's an error, though. I would refile the application immediately. They are accepting some of the refiled applications. We have noticed some they're doing. If by any chance they don't accept it, you may have to wait maybe a couple of months. If we were to believe the State Department, which they normally give an accurate figure, my predictions are not normally right at all in the priority date, but the State Departments are. If by any chance they reject your wife's adjustment of status, You may have to wait until the dates become current again. Hopefully by September, it should be becoming current either on the final action date or in October. We are expecting anyway, with the extra 135,000 green cards coming in, it should be current for your wife also to refile the application.
Awesome. Thank you for the response, Andy. Let's have the caller here, caller ending with 6118. Please press *6 to unmute yourself and go ahead with your question.
Hi. Hi, Sita. Hello, Rahul Garu.
Hello.
Yes.
We really appreciate your commendable service to the immigrant community, Andy, Rahul Garu.
Thank
So
you.
I had electronically filed for my H4 extension on April 16, 2020. My I-94 expired on April 20, 2020. So I applied just within time, and I got my 539 receipt notice in mail. I'd applied for H4 EAD in June, got the receipt notice in mail. But on November 2nd, 2020, I missed my biometrics appointment because of the missing biometrics appointment notice in mail. So my case status was updated online saying you have been scheduled for biometrics appointment, and if you do not receive the mail by November 9th, please call the 1-800 number. So I checked my online USCIS case status and discovered that the biometric notice was issued on October 11th and probably mailed out sometime October 14th. But since I did not receive it in mail, I printed a copy of my biometrics notice, and on November 5th, I tried calling USCIS, and I also tried to fill out the missing notice form on USCIS website, but that tool was not working and giving an error, and it still does give an error. So as per their message, I waited till November 9th and called them again, and the USCIS created a service request on my behalf saying that the notice was missing, and the service request was submitted by the USCIS agent. Now on November 19th, I got an email response from USCIS for the service request, saying that they sent me a biometrics notice and USPS has not returned that notice to their office. In addition, if I miss my fingerprinting appointment for any reason, I may submit a request to reschedule the appointment. And the request to rescheduling must be submitted within 87 days of my original appointment notice. And I must include the original fingerprint appointment notice. So, but since I did not receive the original appointment notice, I sent them a copy of the notice. I was able to print it online from online, and the handwritten letter requesting for rescheduling, and I sent it via the USPS 2-day priority mail, and I have proof of delivery from USPS and the tracking number, etc. Now, USPS received my request on request to reschedule on January 4th of this year, within 63 days, much before the timeline they've given me 87 days, but I sent it within time. On February 5th, again, I called them saying, I'm still waiting for the new biometrics appointment letter, and they advised me to continue waiting due to the delays currently because of COVID, etc. And all the phone calls that I've made to USCIS have been recorded, and all the notes was documented by the USCIS agents. But on March 16th, that is last week, my case status got updated to denial, and I'm yet to receive it in mail. But the online denial notice says, since I have failed to appear for the scheduled biometrics appointment,
in short form, they sent you the biometric, you didn't receive it, you didn't went, you have all documents for rescheduling. They didn't reschedule, they denied the H4, okay? Now.
Yes, MTR.
Okay. What's your question now?
So, so they said I can file for motion to reopen with evidence. And on March 17th, again, I called them and I told them what happened.
You're going on and on and on. I got the point.
Okay.
That the biometrics. So you have two options. Okay. You have three options. One is motion to reconsider. Second is to file a H4 one more time and EAD one more time. The third option is that you leave the country and go for the H4 stamping and come back. Now you have gone through a bureaucratic process of what you're speaking about. You did 20 different processes to get your biometrics. They didn't. And if you do the motion to reconsider, though, it may take maybe 1 year. They may give you in 2 months. They may take you 1 year. If you file for the H4 extension under the non-protunct also, it may take almost 1 year for you. The best method right now is for you to go outside the country and get the stamping and come back. Now you can follow the methods. What you can do what you told again, document everything and do everything 10, 20, different 30 times. You may get a positive result. My advice is just go get the stamping of H4 and come back.
Okay. My one thing that I was missing there is we are ready to file for our 485. because our final action, my husband's final action date is current as of today, and it will remain till the end of April. So are we eligible for under INA section 245K employment based less than 180 days to be eligible to file for
you could
AOS?
be, but I would still suggest that you do the stamping and come back if you can. You said the final action date is current in April. Is it because you are in EB1?
EB3, because it's we're in EB3. It's been current. Yeah.
Why did not you file your application? Why did not you file the application before?
His date of birth certificate, something was missing, so we were waiting on the documents. And meanwhile, I got this. We were ready to file, and then
you don't need date of birth certificate to file it. You can always file the application. Do an affidavit and file an application. You can get the date of birth certificate later on. I don't understand why you wasted all these 6 months. You would have been a much better situated though. And right now, the final action dates are not going to move that backward. You will get in May, final action dates of May, you will get in April. My suggestion to you is just go and get the stamping. I know the efforts you're trying to do, but they are not proper though. Certain times, just easy to just go outside the country and get the stamping and come back. And I think so that you need to re-strategize yourself. I don't understand why you did not file the additional status in October. It is really beyond my understanding.
No, he was waiting for some documents. There was an expungement record that he was waiting on. It was in my
expungement. These expungement records are not applicable for immigration. It is not applicable. No expungement record is applicable. So no matter what anybody does, any expungement, when it comes to the immigration, when you fill the form out, I'm not going to tell the details of what it is, but you have to answer yes to that question. You cannot answer no if you have an expungement. Expungement record only is applicable for you to apply for people applying for the jobs, not for immigration. So I would advise that you should be contacting a proper lawyer before you're losing all these things here and there and doing all these extra steps and straining yourself and making a big loss for yourself. Next person, please.
Thank you, sir.
Thank you. Thank you so much.
Let's take the next caller here, Andy. Caller ending with 2345. Rahul garu, YouTube question and then Nikada. It is from Vijay Srinivas, and his question is: my L1 visa is expiring in June 21 and have filed for 485, I-31 and 765 in October 20. My dates are current. What are my options if USCIS doesn't process my EAD before June? And also there is a question of why there is so much of backlog in processing time.
If his EAD is not processed by June, he's an L1B, so he cannot extend the L1B. I'm assuming that he has completed his years of period on L1B. So definitely he can stay in United States. Absolutely not a problem, but he cannot work in United States.
Okay.
He has to wait until the EAD approval. If he has any L1B left over, he can file the extension. If that's not there, he can stay in United States legally, but he cannot work.
Okay. So that's your answer, Andy. Thank you so much, Rahul garu. So we have the caller here, caller ending with 2345. Please make it crisp, your question, so we give time for other callers as well.
Sure, Sita. So, hi Rahul, how are you?
Doing good.
I had a quick question, Rahul. So currently my wife is on H4 EAD and she's working for a client. And her EAD will expire soon on like September 2021. This week I'm planning to get an extension in the premium. And my wife planned to India and get H4 stamp and come back and apply for H4 EAD. And then here is my question. So after H4 stamping, the current EAD will be gone, or she can still work until September 2021?
She can work until September 2021.
With the existing one.
That is absolutely right, sir.
Got it. Yeah, this was a confusion to me. Yeah, the other small question was, you're telling that dates will be rapidly moved, right? So can we hope like EADs for 2016 Friday dates will be current 2022 fiscal year?
I am one of the worst guesser of priority dates. I just repeated what the State Department has said. They really control the numbers. They have a lot more numbers than I could possibly digest. Their whole department, the visa allocation department, there are certain employees, all their work is to crunch the numbers and tell when the priority date is going to move. And they announced it at 135,000 green cards extra will be given to the employment base. As Sita Garu said, that just we got 100,000, the priority dates moved almost 4.5 years. So now you do the maths. I'm not a good mathematician.
Hoping for the best.
Got it. Yeah.
But
thank you very much.
Thank you. Yeah.
Thank you so much. Let's onboard. Thank you so much.
Sitagar, I want to take the occasion for the people who are contemplating moving their jobs. And if you don't have a labor and I-140 approval with the current company, you may actually want all these steps to be taken right now. Okay. If I were you, if I have an I-140 approval, I'm not going to move the job right now because it's taking a long time to get the labor and I-140 approval with the new company.
Got it.
The next.
That's a very, very useful advice that you're giving, Andy, because there are a lot of people switching jobs because of whatever happening around. But thanks for the advice, Andy. Let's take the next caller. It is caller ending with 9466. I think that's what I see here. But we also have a YouTube question here, Rahul Garu. It is from Sudha Stanley. So the question here is, can a person work on H1B and an EAD simultaneously in 2 different projects?
They can, but practically if you're working on adjustment of status EAD, it is making your H1B ineligible. It will be considered that if the USCIS is going to ask a question, are you maintaining the H1B? Once you use the adjustment of status EAD, that means that you're not maintaining the H1B, because on H1B, you can only work for one company unless second company files a concurrent H1B filing. So once you use the EAD, legally speaking you're actually working with 2 companies with the EAD, not one H1B, one EAD.
Correct. Okay. That's your answer. Let's take the caller question, and it is from 9466. Please go ahead with your question.
Hi, can you hear me?
Yes.
Yes, ma'am.
Okay, yeah. So this is my question. Yeah, I applied for EB3 downgrade in October. My I-140 is approved and I received my EAD card.
Nice.
If I get fired, thank you. If I get fired from my job on the 150th day of application, will it affect my current I-485? Or
Yes,
can
it
I
does.
apply for, it does affect, that's what you're saying?
Yes.
Okay. Can I apply for I-485J portability with the new company after 180 days, even though I'm fired on the 150th day? Can I do that?
Technically speaking though, if you lose the job within 180 days after you file the adjustment of status, your adjustment of status should be denied. They're going to ask clear questions when you're filing a 485J supplement. That did you have the job with the existing company for 180 days? So at this point of time, though, my suggestion to you is if you can keep the job for 180 days, you will avoid people like me. You will avoid people like me. And you should avoid people like me. If you cannot do that though, I would want you to consult an immigration lawyer privately rather than the TV though. But if you possibly can, I beg you, can keep the job for the next 180 days, that will be in your best interest, absolutely best interest. It will be cheaper, better, I don't know how to say. But if you cannot, though, I want you to consult privately.
One thing what I was trying to take time off for the remaining 30 days using FMLA, but that won't affect my I-485 or H1B application in any way, right? Like if I somehow extend it for another 30 days.
Yeah, the question is that were you on leave after firing or before firing? That's my main question. I would still suggest you that if you cannot keep the job, because this is very sensitive and this may poke to a lot of different, you'll be opening a box of worms, okay? I would recommend that you consult a lawyer privately if you can't keep the job. If you can keep the job, you know the answer. Everything is fairly simple. After 180 days, if you can't, you would rather discuss these things privately with a lawyer rather than on the TV. Okay.
Okay, sure. Thank you. Thank you so much.
Thank you. Thank you very much.
Thank you. Let's take the next caller here, Randy. It is caller ending with 0403. Rahul, I think the question that we have next is from Varsha. We would have taken it already. It is on the similar lines of EB3 down then So we'll skip that? Or
yeah.
Yep. Okay.
Yeah,
let's take the next caller. Next question here. The question. Okay, let's take the call question. Sir, can you please go ahead with your question?
Yes. Hello.
Yes, sir.
Can you hear me?
Yeah.
Yes, we can.
Hi. Thanks for taking my call. A couple of months ago, I had a pleasure talking to you regarding my spouse 485 rejection. Mine was accepted and her rejected. And after that, so they mentioned in that file that the application type was a mistake. We did correct it. That was on page number 3A. They said I should have clicked on it, and when I went for a review with a lawyer, and I resubmitted. That means I resubmitted my wife's 485, which was rejected. And again, mine cases is going forward. Again, second time they rejected our application, saying that the filing fee, incorrect filing fee, though the filing fee was correct, which is $1,225, which includes biometrics and the 485. We did apply I-765 and one though. In this scenario, what would be the best thing that I can do? So though I filed properly with the money, and they rejected keeping 3 months with them.
When did you file the second application was received by USCIS?
That was December 18th.
So it was, the prior dates were still current at that time.
Fortunately, mine is EB1A category that is current now, and I believe it will continue to be current.
So refile the application though. You may want to check it thoroughly. I want to get the entire forms redone again though, because I see that there may be some fault that you both guys are not noticing it. They could be giving lame reasons. Your final action dates are current right now. My danger is, I don't want you to get the green card right now, believe me.
That is the problem. Problem is that they even sent RFE for my medical. Now, that's the second thing that I want to ask is that, like, when I send my medical, can I send her medical also along with me?
First first I want you to do one thing. Refile the application ASAP, okay? This week, that means starting this April 20th this week, though, I want you to refile the application. And make sure it will be reviewed by a different lawyer than the lawyer that you have already worked on. Make a fresh check, okay? That's number one. Number two, don't respond to the medical RFE. You have an extension that is there based on the COVID. You can respond to the extension later on. The reason is that I don't want your green card to be approved. Most of my clients, I would like to have the green card approved. But in your case, I don't want your green card to be approved. So that is very important that you delay the medical and file. When you file your wife's application, file along with your wife's medical though. Okay? Thank you.
Okay.
Very much.
Okay. You want me? Okay. Thank you, sir.
That's good.
Thanks for helping.
Let's take the next caller here, Randy. It is 9860. Caller ending with 9860. So here I have a question, Rahul. So there is a question around the processing time delays because for the prevailing wage and the PERM. So is there any improvement there? And what are the reasons?
Yeah. To say that this is taking ever for us to get the labor.
You wear the jacket and helmet, baby. You'll be late. Go.
This is, I think they've gone on mute.
So the prevailing wage is taking about 7 months. The labor simplification is taking about 7 months. And there is an interim process in between which might take 4 months. You're speaking of approximately 18 months to get the labor certification. which used to only take less than 8 months for the entire process before. So please be aware, people, when your H1B is expiring, you're coming very near to 6th year, you may be in big danger. If you're in the 4th year, if you have already not started the process, you should consult a lawyer for alternative provisions, what you can do. Sometimes if you spend more time outside the country, you can gain some time. Sometimes people have the H4 options. There are different creative options lawyers can come up with. If you have touched 4 years and you have not applied for the green card, it is absolutely important that you contact a lawyer. And the other thing is that if you're trying to contemplate changing the jobs, and if you have a labor in I-140 right now, maybe it's not a right time to do it. Because if you change the job and you go to the new company, and the new company files a labor certification prior to it becomes current, oops. Now you can't go back to the old company, you can't go back to the new company. We, Hyderabadis call this neither garka nor gatka. So you be careful if you are intending to change any company right now because of the delays in the labor certification.
That's a good call out, Andy. Thank you. We have the caller 9860. Please press *6 to unmute and go ahead with your question, Andy. Caller ending with 9860. Please press *6.
Yes, ma'am. Are you able to hear me?
Yes.
Yes.
Yes, sir. So I'm going to India next week, sir, and also have H1 Dropbox appointment in the first week of April. So my question is that after it is approved, is there any way we can initiate the H1 amendment? Because I want to move from Virginia to Dallas area. At least start with the LCA process while I'm in India.
Well, you can start the LCA process though. You can start the LCA process. It's not advisable that you file an amendment while you're outside the country. Right now you're in Virginia, is that right? At this point of time?
Sir.
Okay. You can file an amendment the day you land into the country. There's no requirement that you have to wait a certain period of time. But I would not file an amendment because it's going to create a confusion at the port of entry. It may also create a confusion in the consulate. Hey, you're saying that you're going to work in Virginia, but now a H1B has been filed. You know, most probably your end client is not changing, I'm assuming. But they don't look that way though. The consulate look into, ooh, maybe this end client has changed. I don't know. I can't see this one. Let me put this guy in 221G. Boom, you're gone. So that's the reason I would recommend, you can file an LCA, but wait until you enter into the country. The day you enter into the country, you can file an amendment.
Okay, sir, will do. You have a great day, sir. Thank you very much.
Thank you so much.
Thank you very much.
Thanks for tuning in, and we are here back to take all your questions, and thanks for all your continued support on TVASIA Telugu. Let's take the next caller here, Andy. It is caller ending with 1616. And before that, Rahul Garu, we have a pile of questions on YouTube. I'm taking the YouTube question here. Or let's go to Facebook question, Andy. The question here is, it is an F1 OPT filled on January 7th at California Center. It's been 2.5 months. The center's wait time increasing from 6 months to 11.5 months now. Meanwhile, what options do we have for students? Are there any ways to expedite the process? That is what the caller is asking about.
The STEM extension, you can work even after the OPT expires for a period of 180 days.
Okay.
And the I-9 regulations allow people, if the extension is pending beyond 180 days, they can still continue working based on the receipt notice though. That's a good part about it is the I-9 requirements are met even if it's been extended. And there is an article written on immigrationgirl.com. I want you guys to, this particular person to read that article about delays in the EADs. What are the options that are available? So you can look into that one. Even if the receipt notice is that if you don't have a receipt notice though, you can use the FedEx tracking number as the receipt notice as to substantiate the requirement for the I-9. For the I-9 requirement, you must show that you filed an extension. So if you don't have a receipt notice, you can use the FedEx tracking number. This is allowed by the Immigration Customs Enforcement. In their website, they said clearly that it is allowed for you to work with the FedEx tracking number. Okay. And that article is there on the immigrationgirl.com.
Okay. So that's a good reference to look at. And let's have the caller here, and the caller ending with 1616. Please go ahead with the question.
Hi, Rahul. Can you hear me?
Yes.
Okay. My question is regarding whatever you have been saying, that Department of State spillover will hold good. The date of final action date will become close to, by the end of September, it will be close to the filing action date, right?
Filing action date, what we got for the month of October. That is what he said. Yeah.
Yeah. So, but there are so many people who have downgraded, right, to EB3. So, still, how can that hold good? I mean, even though we have 100,000.
Yeah, we have 100,000. Then we have 140,000 extra green cards. So we have 240,000 green cards, though. Now, the rumor is that it's 400,000 green cards is the rumor, but we don't have an official figure yet, though. So 240,000 is a big number. It's a little bit over 100,000. And the good part for us is that most of this extra 100,000 that we've been allocated for the employment based, who is getting them? Only Indians. Because there is nobody else waiting. And the next 135,000 also, mostly it will be Indians who will be getting it.
Okay. So my question regarding that is, I filed it in October. I'm waiting. Nothing has happened. I received the receipts, but no EIDs or APs or fingerprints or anything. So what happens once my filing date becomes final action date? What happens then? I mean, what should I do once I receive the EIDs? And
we are noticing that the biometrics have speeded up very much for the adjustment of status, though. Even though the H4 EAD guys, they are keeping on hold, they're expediting the 485 biometrics. If the biometrics has happened, and if your underlying I-140 is approved, is the underlying I-140 approved for you? Or is it a downgrade application? Did you do the premium processing? Did you do the premium processing?
Not yet. Not yet.
As soon as you put the phone off, drop an email to your lawyer and employer to do the premium processing, though. Now, if your I-140 is approved, if your biometrics are done, if you have submitted the medical, they may approve the green card without interview. They are doing a lot of that right now for EB1s. Believe me, there are people who are getting a green card within 3 months. And some of the people, just the previous caller, he doesn't want the green card. He doesn't want the green card. Believe me, for some technical reason, he doesn't want the green card. So they are approving the green cards. So if the medical is done, I-140 is done, and biometrics are done, you are going to get, you may be getting the green card when the final action date becomes correct. You may not be interviewed at all.
No action from my side to be taken, any paperwork?
I mean, there is practically no action can be taken. The reason is that the USCIS is telling that they're taking about 15 months to 45 months for the processing of the 485. So practically you cannot raise any service request. You just have to wait for them to act. What are the things that are in your hand is, you better get your I-140 premium processing, because if you don't get your underlying I-140 premium processing, they're not going to give you the green card. First thing. Second thing, if you have not submitted the medical, you can still submit it by doing interfiling. If you have not submitted the medical, they are not going to give you the green card. No. So these two things, you can do that. Biometrics, there is not much you can do. They have to call you, but these two steps, I want you to take care of it right now.
Okay. One last question regarding H1B concurrent. You spoke about it. How legal is it? Can the second job be 20-hour job, not a 40-hour job?
Yeah, the second job can be. It is perfectly legal. Let me tell you one thing. On the I-129, there is a box that says concurrently filed H1B clearly. So it's perfectly legal, absolutely legal. It's legal, and you can even, some of the people, they don't know whether they're going to work 20 hours or 40 hours. The way we mark is that between 20 hours and 40 hours. And we put the salary hourly to them so that it meets a requirement. The employer doesn't have to pay you for the hours that you don't work, and he will pay you only for the hours that you work. So yeah, it could be. And people can work for 2 full-time jobs. Believe me, there are a lot of people who put 80 hours a week. They're good workers and we want their money. And you can work 20 hours extra. Absolutely perfect. No problem with that.
And it goes through the same process, LCA, wage level, everything.
Absolutely.
I mean,
you're absolutely right. But in your condition though, I think so. If I were you though, I would get the premium processing of the I-140 approved. And guess what? Once my EAD is approved, I'm not going to pay money to a lawyer. I'm not going to have any money going to a lawyer paying for my second H1B, because on the EAD, boom, you can work for two companies. You don't need anything.
Sure.
Okay,
Sure.
thank you.
Thank you so much.
Thank you very much.
Thank you. Thank you, Rahul Garu. Let's take the next question. The caller is 9076. And before that, we have a question on YouTube. So the question is, I have I-140 with the priority date of 2013 in EB3. Currently working from Canada in PR for the last 3 years. Am I eligible to get visitor visa, or will there be any issues with the intent because of the approved immigration petition?
If your intention is only to come into United States, you're still eligible to apply for the visiting visa though, or business visa. The only thing is that when you apply for the DS-160, that's the application that you fill to get a visiting visa, you have to mention that your I-140 has been there. Have you ever applied an immigrant petition? You answer yes and give the details. The only thing is now you have to convince the consular officer that even though you may have had an immigrant intent long time ago, right now you don't have that intent, and the visits that you're going to make to United States are only temporary. You just have to satisfy those requirements. Okay. I have seen many of those people getting the approval. It's not like a complete ban. Just because you have an I-140 approval, they will not ever give you the visiting visa. That is not true. People still get those visiting visas. It's not a problem. Awesome. But you just have to satisfy the requirement that you had an intent, but you don't have an intent right now.
Okay, perfect. So let's take the caller question, Andy. It's 9076. Please press *6 to unmute yourself and go ahead with your question. You again are on mute. Go ahead with your question. We can hear you, Andy.
Hello.
Yes, go ahead.
Hello.
Yes, sir.
Yeah, this is actually, I called you, sir, before about son. He actually got into the college. He is doing his undergraduate. Now we filed actually for I-485 with him downgrading to EB3. I think at the time you advised us to include him also. But the question I think I was hearing later on, I saying that don't use the EAD for him. So he actually wanted to use it for his internships and some research.
No. I don't want him, or I don't want you to use the EADs right now. The reason is that if he uses the EAD, he loses the H4 visa. How old is he now?
He's 18 years, like 3 months now.
It's going to be tough though. I know that, if he wants to go to medicine or something like that, he needs to do the internships and other things. Wow. And now the State Department has said that the final action dates are going to be the same as filing dates though. And he's still 18. And then we have extra $135,000 green cards that are coming in October of 2021. It's a gamble. Still, it's a gamble. You see, you're understanding what I'm trying to tell you?
Yeah, but the question is, in his case, because initially I think I don't know, I felt it like a misleading or anything, because there was no advantage, correct, filing him for him, because that's where I didn't get why you advised us to include him also.
Why is there no advantage in filing adjustment of status? You don't want the green card for you?
No, because whenever it becomes final action, totally we can file, correct? Because for him, because no use, correct?
What if the final action date becomes current and they give you the green card?
But he cannot do anything now. Even F1 transfer also, I was talking to my company lawyer. That cannot be done.
No, that's not true. We are filing a F1 transfer. We had no difficulties at this point of time. There may be a hiccup though. Right now he's only 18. I don't see a reason why you don't file an adjustment of status. I would file an adjustment of status. You did a good thing in filing an adjustment of status. But for him to move to the EAD, I would recommend that you consult a lawyer before you move to an EAD, because that will be a gamble. Okay? And your I-140 downgrade application is pending right now, is right?
Yes.
Well, that means that he's not going to become, his 21 years, he's going to be 21 plus the period of time that your I-140 is pending. So he may have about 3 years. So
the question is like, if EB2 becomes current, is that interfiling is going to be, do we need to interfiling or we need to file again to EB2?
If the EB2 final action date becomes current, is that your question?
Yeah.
I would, since you have not moved to the EAD though, since you have not moved to the EAD, I would choose to file a complete new application though.
Okay.
Okay then.
Thank you so much.
Yeah, and one more question is, if I go to India and come back on AP, advanced parole also, it's considered using it EAD?
That is right. Then you are considered to be married to the adjustment of status. Your son then moves to the adjustment of status, not, since you don't maintain H1B, he's not an H4. I want you to watch the video that we made exclusively on children becoming 21 years. We made that 1 month ago. Just watch that video, okay?
Okay.
Thank you so much. Let's take the next caller here. Caller ending with 9623. The caller ending with 9623. And before the caller's question, here is a question on YouTube. And it's about the downgrade of, so the question here is, my downgrade I-140 request for premium processing got rejected the first time. What my attorneys can do, differently on the second.
Keep filing. Put a notice saying that do not reject in the mailbox. Keep filing. There are cases, I would say that, out of the, I would say that about 3%. Can you hear me? Yeah, just hold on for a minute, ma'am. 3% of the cases of the total cases that we filed are still rejected. After 5 times, they're still rejected. I would say only 3% of it though. But 97% of them, they got tired of it, they accepted our money, and they approved the cases. Keep refiling. I mean, every time you get the rejection, you're not losing the money. The $2,500 is not going anywhere. All it is costing is the FedEx cost again. We get the rejection, we put it back. Get the rejection, put it back. They're accepting it eventually.
Okay.
Go ahead, ma'am. Sorry, I interrupted you. Go ahead, ma'am, with your question.
Thank you, Rahul and Sita, for taking my call. My question is, I downgraded from EB2 to EB3 in the month of October. All I received is the receipt notices, no movement on that side. And now I am current in the final action date. So I asked my company's attorney to upgrade it to premium, which they did. They filed on February 24th. And when they filed, their response to me is that if they accept, I'll receive an update in the email in 3 to 4 days. If not, I'll receive the return package in 3 to 4 weeks. It's more than 4 weeks. And when I contacted them, now they are saying it may take several weeks. So they are kind of indicating that it is rejected. But it's very confusing on the timelines. How do I know that they did upgrade?
You can do one other thing, ma'am. If you are wanting to get this one approved faster, especially if you have any kids or something like that, though, I would do one thing.
I do.
You do have a kid. Okay. And coming near the, how old is the kid?
She is 19 years, 6 months. So I'm really, I'm counting days.
I got your point. Here is what I would do for you though. Okay. You know what juggling is? It's like this. You know what this is called, juggling. So what I want you to do is that you file one premium processing, it's pending. File one other one.
Okay.
Keep rotating until you catch one of it. Yeah.
Okay. I wasn't sure because the way the attorney said is that we have to wait until the package comes back.
I would not. You can have your employer file it too. It's so easy because what do you got to lose? If ever, most probably they won't ask. Once they give a receipt notice for the first one, they won't give the receipt notice for the second one. Even if they do, if I were you, okay, because you're counting the dates, I don't care about the extra $2,500. I want my premium processing to be approved. So for that reason, keep filing. One goes back, you keep filing. Okay? That's a safer method for you.
Can I ask, thank you so much, Rahul Garu. I do have a question. Can you please help us understand how exactly does this premium process work? You send it by email, or why did my attorney said I would receive something in 3 to 4 days or the rejected package in 3 to 4 weeks?
I would not say that you would receive the receipt notice in 3 to 4 days. I would say that when you send the premium processing, if they accept it, they send an email to the lawyers, which normally used to come 3 to 4 days. Nowadays, it's taking about 7 to 10 days. Now, the reason why he's telling that rejection is taking 3 to 4 weeks is because if they reject it, they don't send it in the email. They send it by a mail. And the mail takes a long time to get it by the time they reopen it and all those things. That's the reason he's saying that it's going to take 3 to 4 weeks or even certain times, even longer time too. So I would not wait for the rejection. I would refile it. I would file one more application. Even if the $2,500 is there, you file one more. Until one application is accepted, you keep on refiling the same thing.
Okay. Thank you so much. Thank you so much,
Thank you,
Rahul Garu. Thank you.
Thank you, ma'am. This I-140 premium processing is a little bit puzzle for a lot of people, guys. It's a hit and miss. We don't know why they are accepting. We don't know why they are rejecting. It's just like a lottery, according to me. So that's the reason I'm telling people, keep refiling it, keep refiling it. And especially with the kid of 19.5-year-old, when the final action date is set, two balls, keep hitting the balls. One will hit one sometime.
Yeah, there could be luck sometime, somewhere at the end of the time, there is a ray of hope there. Thank you, Andy. We have the caller here, caller ending with 4628. Before we take the caller's question, let's have a YouTube question, Andy. The question here is... Yeah, go ahead with your question.
Hitting the balls. One will hit one sometime. You may have to mute your TV, sir.
Could you Can you please go on mute? This is for caller 4628. Please go on mute. So yeah, that's good. So we have the question here, Rahul Garu. It says, I have received the 485 approval notice in November 2020, but still pending for the I-485. How long does it take?
Wait. He got what approval now? 485 approval.
485J approval notice.
Approval. Oh, 485J approval. Okay.
Yeah, sorry. But still pending for the 485. How long does it take for the approval after the 485J notice?
Assuming if the final action date is current, though, that's the main key point, though. If the final action date is current, he could be getting the green card any day now.
Okay.
But if the final action date is not current, he cannot get the green card. That's important. Okay. And also, I'm assuming that his biometrics have been done, his medicals are been done. If by any chance he filed adjustment of status in 2010, if the medicals are not, there is no RFE for recently on medicals, though, he should submit the medicals again. Okay. But if the final action date is current, if all the other things are fine, he should be getting the green card any day. If the final action dates are not current, he will not get the green card.
Okay, so that's your answer. Thank you so much. And thanks for waiting. This is for the caller 4628. Please press *6 and go ahead with your question. Caller ending with 4628. Yeah, we could actually probably go ahead with our YouTube question in the meantime, Andy. The question here is so the caller is the viewer is on the 7th year of H1B with 180 days after approval of I-140. Visa is not stamped using the latest approval. So looks like they're planning to go back and come back after a year. So what are the options or process to come back to US again through the same employer or a different employer, and how complicated is it?
Assuming the I-140, he told the I-140 has been approved for more than 180 days.
Yeah.
He can come back anytime from India to here.
Okay.
Anytime. When I say anytime, I mean anytime before he dies, whether it's 1 year, 2 years, 10 years, 20 years, 30 years, he can come back. He just need another job offer, of course, and that company needs to file a H1B. He has to go for India to get the H1B stamping and come back. Does it has to be with the same company that filed an I-140? No, it doesn't have to be the same company. It can be any company that can file a H1B, get the approval. And a lot of people are under assumption that, oh, you can only come back after 1 year, 2 years. There is no time period. It could be 30, 40, 50 years you can come back afterwards.
Awesome. So that's your answer. Do we still have the caller 4628? Please press *6 to unmute yourself. And can you ask your question?
Can you hear me?
Yep.
Yes, ma'am.
Can you hear me?
Yes, ma'am.
Okay. My question is that I have filed my I-485. My H1 visa is going to expire in June 4th, and I'm on EB3. My current date is my priority date is 2014, and the current is 2010. Should I maintain my H1 visa just on a safer side?
I'm not going to answer your question, but I will tell you one thing. If I were you, if the I-140 is, your underlying I-140 is already approved, is it right?
No.
Yes.
Yes.
Yes. I would not maintain the H1B if I were you. Now, there are some minus points of not maintaining, but there are so many plus points in not maintaining the H1B extensions. I would not. If I personally will not, I'm not telling you what to do though. I'm just telling I personally will not maintain the H1B. If my I-140 is approved, if it's been more than 180 days, and I don't have any kids who are more than 15 years of age in the adjustment of status application, I will not maintain the H1B or H4.
Okay. And my second question is that my husband is on H4. His EAD is going to expire on June 4th. He cannot work until he doesn't receive his EAD. So what is the option for him if he wants to work?
When you say he cannot work until, did you already got a 485 EAD or not yet?
No, not yet.
Well, yeah. If he doesn't get the 485 EAD, and if he doesn't get the H4 extension EAD, okay, he cannot work. Right now, for the adjustment of status EAD, it's taking approximately 8 months for them to give an EAD.
Okay.
Okay?
Thank you.
Thank you.
And my son is 18. Yeah, my last question is, my son is 18 years and 3 months. How safe he will be? Because my current date is, my priority date is 4 years.
Right. If your son is 18 years, that's an exception. I will maintain the H1B, ma'am. I told you that if the child is more than 15, I'll maintain the H1B because you don't, there is a video that I put it on why you should not get married to the adjustment of status. And it's Reddy Neumann. If you type it, you will get that video exclusively in the age of kid. But having said that, though, it looks based on the statement made by the State Department. He looks to be relatively safe compared to what I was estimating about 3 months ago, or even 1 week ago. I was estimating differently, but based on the statements right now, all you need is that before this guy turns 21, you just have to have a final action date to be current, which according to his statement should be current in September of 2021. Okay?
Thank you.
Thank you, ma'am.
Okay.
Yeah.
Thank you.
Let's take the next caller here, Andy. The caller ending with 6925. And we have a very interesting question for you, Rahul Garu. It says USCIS tested 90,000 EP green cards last year. Do they have the capacity to use up to 60K this year? And what is your estimate?
1 week. I was estimating differently, but based on the statements right now.
Can you please go on mute? This is for caller 6925.
Final action date, which according to this statement should be correct. Sita Garu, the extra green cards that we got, there is a good chance that they're going to use it though.
Okay.
Last year, out of the 140,000 green cards though, they did wasted 9,000 green cards. That means that they gave 131,000 green cards. Based on how the things are moving though, when I look into especially EB1 approvals though, I believe that they will be using the 140,000 plus the 90,000, which is approximately 230,000. Most of them, if not all of them, should be used though. And people may say, yeah, USCIS is moving very close, very slow. You're right. But one thing, they're very aggressive on biometrics right now. I see a lot of biometrics getting issued for 485 people. If your I-140 is approved, if your biometrics are done, there is a good chance, once the final action date becomes current, there's a good chance you may be given the green card without any interview at all. And that's going on very aggressively. I mean, I see people getting green card within 3 months in EB1A.
Yeah.
And we're getting this happy EAD and advanced parole rejections. What happy rejections? You know, we don't like getting rejections, but yeah, when you see a EAD rejection, your EAD is rejected because you have a green card. Well, that's good. I take it. I like those rejections. That's happening with the EB1. And there is a good chance that the EB2 and EB3 will move forward. The final action date will move forward. And there is a good chance that they're going to use all 230,000 green cards this year until September of 2021.
Awesome. Okay. So let's hope all of this is really good news and it just materializes the way we are envisioning, Andy. We have the caller here, 3686. Please go ahead with your question. So we could probably shift to a question from YouTube here. And the question here is, I downgraded to an EB3 in October and my dates are current in, I don't know, FAD EB3.
Final action dates.
Okay, yeah. Upgraded to premium on February 24th. Attorney says no update and it may take weeks for response. Please explain the timelines of premium.
Yeah, as I said, that you have to keep on refiling. That's the best option. And if you want to be very aggressive, you know, juggle.
Yeah.
File 2 of them. Use the 2 balls. One FedEx, another FedEx. You'll get one time.
Okay. So the question is like, I think he wants more details on the I-140 premium processing steps.
That's it. Keep on refiling. That's the only thing that I can tell. There's no other thing. Okay. Keep on refiling the premium processing.
Yeah.
There is no hardcore rule.
Okay. So keep trying your luck each time. And so we have the caller here, caller with 3686. Please go ahead with your question. You don't seem to be mute already. Please go ahead.
Hi, Rahul Garu. I have one small question. It will be quick. So my wife is going to India for her H4 stamping in April 17th, and I'm traveling on May 1st. And her appointment is on 23rd, and she's eligible for Dropbox. By any chance, if she was called for an interview, will the interviewer ask this question like, why did you alone came without your husband? Since I have my stamping until July 9th, I'm not willing to go to the
not a major question though.
I want my wife to.
Not a major question that both of you guys have not traveled together. If they ask the question, they will ask the question, are you genuine wife and husband or not? Sometimes we see those questions, especially when the Facebook says that, you know, you are dancing with another girl and then, you know, you're saying it's unmarried and then you put that becomes a problem, but that's not true in your case though. So otherwise, normally the marriage relationships, especially US consulates in India, hails them as very good marriages. So they normally don't doubt the marriage. So unless they doubt your marriage, I don't see that she traveling 2 weeks or 3 weeks before. Yeah, I mean, you know, these ladies want to go to those marriages, especially in the marriage season. There are a lot of different things that why she may want to see her parents much longer than you want to see your parents. There may be many different circumstances. So I am not expecting that as a problem, that she traveled 2 or 3 weeks before you. No, I'm not expecting that as a problem.
Okay, and just one small follow-up question. I know you answered this question for me in the other call, that my wife's current H4 is in progress in USA along with her H4 EAD. Since it is taking so much time, she's going to India to get it stamped. I mean, there is so many answers floating around in internet that saying that this H4 and EAD will be abandoned. But you clarified, in your experience, do you ever seen any situations where it got abandoned?
The answer is very clear. Is it a H4 extension or is it a transfer to the H4? If it's an extension, it will not be abandoned. If it is a transfer to the H4, it will be automatically abandoned and will be denied. If it's an extension, when do we see a problem is that when people don't come to the biometrics appointment, then they will deny the H4. Otherwise, we have never seen anything getting denied because while the extension of the H4 is a process, the person has traveled, they would not deny it. They don't have an authority to do so.
Okay, if she come back and if she gets a biometric appointment, if she attend it, in all will be good, right? And there will
Absolutely.
Is there any chance for RFP?
No, I mean, is there a chance for RFP? There is always a chance for RFP, but 99% of the time, H4s don't get RFP. And her travel does not trigger an RFP. That's a doubt that you have. Why is that the internet is full of things that says that it's getting abundant is because when you apply for a change of status, the rule is different. When you apply for extension, it's different when you apply the change of status. When you apply the change of status, boom, her H4 will be denied. But you told me that she applied for the H4 extension, so it will not be abundant. The only caveat is that the biometrics.
Okay, yeah. The major things I'm seeing on internet is there will be an I-94 difference, and that's why they might give an RFP.
We have not seen that. Even if they give an RFP, that's not it. We have never seen an RFP like that. Okay. Let's go to the next call.
That clarifies my question. Thank you very much.
Sure.
Thank you.
Let's take our last caller on here, Reddy. It is 5875. Let's onboard the caller 5875, and also let's take a YouTube question here. It says priority date is 23rd May 2011, downgraded from EB2 to EB3. If by chance EB2 advances ahead of the EB3 in final action date, this is for the caller 5875. Can you please go on mute while we take a YouTube question? Okay. So the question is, how long will the interfiling process take, and should I get the medicals and keep them ready?
Yeah. Can you repeat? I couldn't pay attention.
Sure. The question here is the priority date is 23rd May 2011, downgraded from EB2 to EB3. If by chance EB2 advances ahead of EB3 in final action date, how long will the interfiling process take, and should I take the medicals and keep them ready?
Interfiling process can be done in one day. The only problem is that will the USCIS get the attention to do the process? It may take 1 week, it may take 10 days, it may take 5 years. Most probably the average time that I see the interfiling getting attention is about 2 years time. That's the reason if you maintain the H1B, I would rather just file one more adjustment of status. So that's one thing. But if you don't maintain the EAD, then interfiling is the best option for you.
Okay, so that's your answer. And let's have the caller 5875. Please go ahead with your.
Hi, Rahul. Are you able to hear me?
Yeah.
Yes.
Yeah, hi, Rahul. Shashi here. So my mother was in US last year, and we applied for her B2 extension. And, after applying, we got the receipt number online. And she left the country in November. After a couple of months, she left the country. Now we have received her biometrics. Okay, so what we have to do now? So that's one first question.
You can request a withdrawal of the B2 application right now. They're going to deny it anyway because she is not attending the biometrics. It's not good to get the denial. So have her write a letter to withdraw the B2 extension. And
so if we
keep the documentation that she has withdrawn the B2 after she left the country, not before she left the country. What is the documentation that says that she maintained her legal status after the I-94 expired? Is the receipt notice that you received from the immigration and the withdrawal notice that you sent to the immigration after she left the country, and the withdrawal confirmation that she gets from the USCIS. These are the things you need to keep it.
So it doesn't say that if we withdraw, it doesn't say that it's overstayed, Rahul?
No, it is not overstayed because she withdrew when? After she left the country, not before.
Okay. So now my second question is, my wife is on her 6th year of H1, and we applied her perm in last year, August actually. So her H1 ends in July. So what are the chances getting perm approval and then, going for one?
They are processing the cases that were filed in July 30th last week. So when I checked it. So there is a good possibility, at least 98% probability that looks that her labor should be adjudicated in the next 1 to 2 months, which is before June. So she should be expecting an I-140 approval before. Now, if you want a backup option, you are in H1B?
I'm on H1B, and I already applied a 485 485 adjustment of status in month of October itself. And mine is EB3, direct EB3. But only thing is my company got acquired by company B, so they have done this, amendment basically.
Mm-hmm. Okay.
So do I need to apply in premium, sir, now, or do you want me to wait till?
No, do it maybe in premium processing. It may be rejected, but do it again. Do it in premium processing. Absolutely do it. Don't wait.
Okay, I will do it then. Yeah. So yeah, you're saying about.
And I was suggesting that if the I-140 was approved long time ago, I would have a backup plan applying the H4 plus EAD 10 months ago, 11 months ago though. I don't know why you didn't do that, but you may still have a backup plan right now to have the H4 plus EAD right now, and without wasting, just in case if the labor takes long time, the I-140 takes long time, if the H1B extension gets denied, I would have an extra option of H4 plus EAD for her.
So she moved from H4 to H1 because of all these delays, and actually H4 EAD.
Yeah, that's up to you though. I mean, right now, if she's getting cornered in the H1B, H4 is an option that she can look into. Okay.
Okay, gotcha. Okay, thank you very much.
Thank you so much.
But I would bet more on getting your premium processing of the I-140 approval, because if that is cleared though, I mean, you are free bird if that I-140 is cleared. You may not need all these H1 and H4s. Thank you very much, Kshetra.
Thank you so much, Rahul Garu. So for the service that you have been doing for the immigration community as a whole, I'm sure everybody is benefiting from all your responses and the questions that you take, the YouTube questions that you answer. Thank you so much for the phenomenal work that you have been doing. And
thank you, Kshetra, for hosting it. Thank you very much.
For having it's great having you here on the TVASIA show. Thank you so much. So that's our talk show with the experts for this week. Thank you.